supremacy of Constitution, separation of powers. The Constitution establishes a separation of power between the legislature, executive, and judicial branches of the government. Federalism. Constitution establishes a federal system of governance between the union and the states. Rule of law. The Constitution establishes our commitment to the rule of law, independence of the judiciary. The Constitution establishes an independent judiciary that can invalidate government actions or violate legislations. Secularism is the fifth criteria. The landmark judgment of Keshwanand Bharati is a leading judgment on the basic structure doctrine of the Constitution. Sakti Prasad case in 1951 ruled that Parliament can amend any part of Constitution under the Article 368, including fundamental rights. Same was the verdict of Supreme Court in Sajjan Singh's case in 1965. However, in Golaknath's case in 1967, the Supreme Court reversed its earlier views that the fundamental rights can be amended, and it said that the fundamental rights are not amenable to the parliamentary restrictions. In 1973, the Keshwanand Bharati case, the Supreme Court held that although no part of Constitution, including fundamental rights, was beyond the parliamentary amended powers, but the basic structure of the Constitution could not be abrogated even by the Parliament. The judgment, in fact, said that the Parliament can only amend the Constitution and not rewrite it, meaning thereby that the power to amend it is not the power to destroy, and it further held that judiciary can strike down any amendment passed by the Parliament that is in conflict with the basic structure of the Constitution. Again, in Indira Gandhi versus Rajnaran case 1975, the Supreme Court applied the theory of basic structure and struck down Clause 4 of Article 329A, which was inserted by 39 Amendment in 1975. Sir, in 1980, Minerva Mills case further strengthened the basic structure doctrine. The judgment struck down two changes made by 42nd Amendment. In 1981, the Bowman Rao case, Supreme Court again reiterated the doctrine of basic structure. In Indira Sawni case, while examining the scope and extent of Article 16(4) regarding reservation of jobs for backward classes, the Supreme Court added rule of law to the list of basic structure of the Constitution. In the year 1994, in case of S.R. Bommai, Supreme Court tried to curb the blatant misuse of Article 356 relating to position of President's rule on states. The Supreme Court held that policies of state government directed against element of basic structure of Constitution would only be a valid ground for exercise of central power under Article 356. Article 356 could be applied only in cases of constitutional breakdown and or the failure of constitutional machinery. Even though Dr. B.R. Ambedkar had assured that this provision would remain a dead letter in the Constitution, but even then it has been misused for 90 times by the Congress government. All the time, it was political consideration rather than any general breakdown, and in most of the cases, majority governments were removed on the ground of political stability. S.R. Bommai case laid down the conditions under which state governments may be dismissed. Sir, during mid-1970s, there was huge political and social turmoil throughout the country. There were economic challenges, social unrest, and resultantly political instability. There was unemployment, inflation, and therefore there occurred widespread protest by the people. Mrs. Gandhi had to impose emergency in the year 1975. As stated by Finance Minister yesterday, there were only 5 leaders in Lok Sabha to oppose the passing of 42nd Amendment Act, and there was none in Rajya Sabha to oppose it. All the big leaders and opponents had been sent to jail under MISA. The 42nd Amendment was brought in, and it undermined the very foundation of our Constitution. It destroyed the Constitution, and Congress government under Indira Gandhi ji completely spoiled the democracy. Sir, इस किताब को खतरा आज नहीं है, इस किताब को खतरा 1970 के दशक में था. The primary object of the amendment was to enhance the power of center and to reduce the influence of judiciary. The Article 32, 226, 131 of the Constitution were amended. Supreme Court and High Court's role of judicial review were curtailed, and it was provided that judiciary could not interfere with the legislative matters. Sir, कल रात एक छोटी सी कहानी बता दूं। इमरजेंसी पर 42nd अमेंडमेंट पर बहुत बहस हो गया है। कल शिव जी आ गए हमारे सपने में। कभी कभी एलएस के एलओपी के सपने में आते हैं, वो दिखाते हैं शिव जी को। मैंने फोटो तस्वीर तो नहीं लाई है। कल आ गए और कहे कि बच्चे, एक बड़े दुख की बात है कि इस संविधान की किताब जिसको बाबा साहब अम्बेडकर ने, डॉक्टर राजेंद्र बाबू ने, वैसे वैसे लोगों ने बनाया, इसको लेके 2-3 आदमी, एक भाई बहन घूमते रहते हैं। जरा सा जनता को समझाओ कि ये क्यों घूम रहे हैं। सर, 1970 में जन्म हुआ साहबजादे जी का, और 1975 में इमरजेंसी लग गई। 75 में इमरजेंसी लगी, तमाम हो हल्ला। हालत ये हुई कि तख्ता पलट हो गया। दादी जी की जो उनकी कुर्सी थी वो चली गई। अब ये संविधान पता चला कि क्यों हुआ, तो उन्होंने 42nd अमेंडमेंट करके संविधान बदल दिया था। अब ये जो संविधान का हुआ, कुर्सी जो पलटी, तो उस समय एक थंडर टाइप हो गया, बिजली गिर गई, कुर्सी चली गई। देखा कि भाई कल तक राजा थे, आज रंक हो गए। और संविधान लेके इसी वजह से दिन में भी सपना संविधान का आता है। तो जनता को यह संदेश है हमारे बाबा शिव जी का कि जनता इस संविधान के घूमने से न घबराए। ये संविधान का कुछ मानसिक संतुलन बिगड़ गया, इसलिए संविधान लेके घूमते हैं, और कोई खास बात नहीं।
धन्यवाद माननीय मन्नन मिश्र जी। माननीय श्री राजू शुक्ल जी।